Excellent.
good to go whenever.
I don't know if Taylor knows what.
Oh, yeah. So nobody charged the batteries, and so I used the last that were charged. So that seems like it works.
Are we waiting on anyone else? Do you have more people coming?
So I think everybody is here from the county.
County? Okay. Then I will go ahead and begin this hearing. Thank you everyone for coming out here. My name is Rob Patterson. I'm the appointed county appeal officer on this case. This is the matter of, and I apologize if I get your name wrong, this Schellenberg? Schellenberg. An appeal regarding a plat approval by the Planning Commission and certain conditions or exactions related to a road and other related matters. Obviously, I'm just summarizing. You'll be able to present your case. And on that matter, could I have the parties introduce themselves, just so I know who all is here to be speaking on behalf of the appellants, the Schellenbergs?
Yeah, so Jake and Tammy. Our lawyers, they didn't think it was necessary to come, but we'll update them on how.
Okay, that sounds good. And do you have anyone else that you'll want to have speaking for you today?
On our behalf, no, but I mean, I don't know, the county can put into how long the process.
Okay, thank you. And then for the county?
My name is Taylor Sorensen. I'm from the Cache County Attorney's Office. Our office generated an opinion on this matter for development services. But I'm happy to share that opinion. I delivered it in writing to you last night and to the director. So if you have any questions on that,
Okay. And maybe I'll explain how I was anticipating handling this, and then if there's any questions or concerns, we can talk through that and work through that. This is a hearing. It's not quite the level of a court. I'm not nearly as important as a judge, but it's still a very important process, especially for the applicants as well as for the county. This is a hearing, but not a public hearing, meaning it's not open to the public to participate, though the public is certainly welcome to be here and attend and witness the events. I was intending to handle this somewhat in lines of how a court would handle a hearing, where we'd ask the appellants, who are the ones kind of presenting the case, to state their opinions, make any arguments or state the facts, ask what you want for me to decide. Turn over to the county if you have anything else you'd like to add on top of the written materials, and then give it to you for the last word to respond to the county.
Yeah, that works. Or if the county wanted to go first, because they sent theirs late or yesterday evening.
Yes.
So we have anything to respond yet, so if they wanna do theirs first and then.
If you would just like to reserve just for kind of the response, I don't have any concerns with that. County?
Yeah, I'm fine with that.
Okay. So before we do that, however, I want to introduce or go over my understanding of what we're dealing with and my understanding of what the law and the process is here. So, as I said, I'm the appeal authority. I'm not a county representative. I don't get to make the county rules. I just get to decide whether the county violated state law in applying their rules. So as part of that, I have a lot of restrictions on what I can and can't decide. So I can't say whether an ordinance or a code is wise or not. All I can say is, was it applied properly in this case? I'm also constrained a lot by the County Land Use Development Management Act. I'll call that LUDMA. It's just an abbreviation. It's the state law that governs how land use applications work for counties. As part of that, my job is to look at, is the county's decision legal, meaning did it comply with all governing law? And then on the factual side, in what the county looked at to make the decision, the evidence, the facts, the considerations, did the county have substantial evidence? And I put substantial evidence in quotes because it may not mean what you think it means what the state says it means. Substantial evidence is a standard that says, do you have, the language is literally from state law, more than a scintilla of evidence? And is it enough that a reasonable person could come to the same conclusion? Doesn't mean, is this evidence enough that it makes it clear that it is the right decision? It is there enough to support the decision? So that's what I'm looking at coming to this case. And on this case, my understanding is we have a plat in the county that the appellants, Schellenbergs, applied for. I believe it was a 3-lot subdivision. Great, we're getting the plat map up here. As part of that, they obviously were required by the Planning Commission, who approved the plat, to put in certain improvements. Some of those are at issue here today. So we have the 3 lots. There's a private road that connects it. My understanding is, and when you come up, please feel free to correct anything I say. I might get something wrong, having just read what the written documents were. But the private road, kind of on the north side there, isn't really at issue. The utilities, the sewer, water, all of that, not really an issue. It's that road on the west there, that kind of curved road. When the county staff looked at the plat, both the planning department and the public works side recommended that that road be developed, or improved, I should say. It exists to some degree, is my understanding, to the major local standard. And that would be for the full width of the road, for the entire length of the subdivision frontage there. That approval was made, let's see, I believe in August of 2022, August 5th, 2022. I have a letter from the Planning Commission issuing the approval, adopting those conditions, including the conditions related to 2400 West there. There was then, about a year later, an extension the Schellenbergs requested because the plat was going to expire after the year, and then this appeal followed, challenging whether that is a lawful exaction, meaning under the Fund-Nolan-Dolan standard from the Supreme Court and the LUDMA standard, is that road, is there a nexus to the government interest? And then the more important issue, I think, in this case is requiring the full width of the road to be borne by the developer roughly proportionate to the impact of the development. And that's, I think, the key issue here. My understanding from reading the brief from the county last night is they've raised some responses to that. They also raised the issue of timeliness. Essentially, my understanding of the county code is appeals from land use decisions are required to be filed within 10 days after the decision. And the county position, as I understand it, is the decision was made at the very least back in the 5th of August 2022 when the county sent the approval letter, so any appeal should have been filed 10 days after that. I assume you have a different response to that, but that is my understanding of kind of the 2 major issues. We have a timeliness issue, and then we have this exaction rough proportionality issue related to 2400 West. So, with that, maybe I'll ask the county if you have anything you'd like to add regarding your position, or if you just want to kind of address it on what you've submitted in writing.
Yes, I would like to point you to what we submitted in writing. I'm much more eloquent writing than speaking. However, I will bring a couple of points to your attention. The county code allows for 10 business days, which is materially different than 10 days. The minimum standard for an appeal time under Utah code is 10 days to appeal to an authority. So the Utah County Code is actually in excess of that minimum standard. And I want to point you to the timeline at issue here, that the Planning Commission made their approval with the conditions at issue on August 4th, and the applicant to appeal under the county's timeline should have submitted their appeal by August 18th of 2022. That appeal was actually received on August 15th of 2023, 269 business days after the cutoff, using that same metric of business days. And so that, I just wanted to point you to that fact, and I just, I think that's the first issue that should be looked at.
I did have a quick question on that.
Yes.
When I was reading the code, I think this is part of why I'm here, but the appeal process was amended fairly recently. In May, I think this county's code regarding land use appeals was amended. I saw an ordinance of like May of 2023. Do you know if timelines were any substantially different?
Yes, I can fill you in on that. The amendment to our appeals process was actually the creation of your position, the land use appeal officer, whereas before we were operating under a board of adjustments system, which was pretty much defunct. We didn't have enough members on the board, and we weren't able to address appeals in a timely fashion. So, but none of that is relevant because an appeal wasn't received until August, until well after that change had been made. So,
Was there a different deadline, if you can recall, for an appeal, or was it always roughly the same?
the appeal's been
Okay.
10 business days for some time now.
Okay. So I think I understand that argument from the county regarding the timeliness issue there. Regarding the exaction issue, I realize that if I decide that it's untimely, that kind of resolves the case, but I'd also like to consider this while we have everyone here so I can hear and kind of fully understand that issue as well. My understanding is we have some recommendations from staff regarding the improvement of this road. I guess maybe just help me understand why is developing a full roadway width for a 3-lot subdivision a roughly proportionate impact, or roughly proportionate to their impact?
Sure, and if you don't mind, if we could just jump back to my second point, that these conditions are actually required under county code, and what we're looking at is, whether or not this land use regulation is preempted by or contrary to state or federal law. And this condition that was placed, condition 5, that requires the applicant to bring it up into compliance with a major local road, that is just reflecting a piece of our county code in Title 12, 02.020, that says that roads in a new subdivision or development must connect to an existing county road, and where the connection to an existing county road cannot occur within or immediately adjacent to a new subdivision, the subdivider or developer must acquire the needed rights-of-way and construct the required improvements at the subdivider or developer's expense. That condition is directly tied to this part of our county code. The Planning Commission, according to my perspective and the county's perspective, the Planning Commission didn't have any discretion of whether or not to offer that condition. That condition is arises because of county code and because it's required under our law. And so,
So I think I see the point. I mean, the commission obviously has to interpret and apply the code as it's written. That's their job. And LUDMA says you have to apply mandatory requirements of the code. I guess what I'm perhaps maybe struggling a little bit with, and maybe I'll also preface this, I will ask a lot of questions because I'm trying to understand a lot of things. I don't want any party to take the fact that I'm asking questions as indicative of how I'm actually feeling on the substance of the case. I'm trying to push on issues that I think are sticky because I want to make sure I fully understand them. So in that vein, I don't know that, at least my perspective is, I don't think just because a code requires something that it is exempt from the Nolan-Dolan and exaction analysis. My understanding, so if the county or a city had a requirement that every new subdivision dedicate 50% of its land and build a park on it, I think that's still subject to the exaction requirement. So that's, and maybe I'm wrong on that, and I appreciate any insight you have. My understanding is, county code says the planning commission has to do this. But my understanding under federal law and takings law is whatever the county requires from a developer still has to meet that standard. Either the Nolan-Dolan standard or the LUDMA standard, which are essentially the same.
I agree. And I just wanted to raise that point that this condition, you know, when we're looking at the Nolan-Dolan standard, we look at whether or not the link exists between the legitimate governmental interest and then whether the exaction is roughly proportionate. And that roughly proportionate standard is directly tied to the whether it's related in nature and extent to the impact of the development. And so that, you know, just going through that standard in Dolan, that dedications for streets, sidewalks, and other public ways are generally reasonable exactions to avoid excessive congestion from proposed property use. One of the appellant's main points was that the dedication of an easement should be offset against the cost of getting the road up to standard. That can be thrown out right immediately because dedications for easements and other public ways, that is per se a reasonable exaction. And we're not asking for an easement greater than the road width. We're not asking for an easement that is substantially larger for a road classification that's above a major local. In fact, my understanding from Public Works is that the easement that currently exists for that curved road that we see, we would vacate that easement in favor of this straighter road.
You know what?
And so,
While you're on that point, I just want to clarify, make sure I understand. So there are two easement lines shown on this plat. Which one is the road that's supposed to be built?
the road
I'm
that
just gonna stand up.
the road that is to be built is the one that is not as curved.
So that is the road being
What it
built.
currently exists is the one that curves to the left and then,
Okay.
Okay.
So that's current, and so it shifts more to. We know why that shifted like that.
the reason for that is for health and safety. So the current speed limit on that road, when people are coming out of, so this is a mountainous, it's at the foot of a hill, basically.
Right.
So people are coming down this hill. According to the manual, the standards of the roadway manual, that curve is too sharp, and drivers who are unfamiliar with the area, who are driving through, and drivers who are familiar with the area, going down that hill are more likely to slip off, which is why it needs to be straightened out to come back into standard.
That's helpful. Thank you.
But, so returning back to this discussion of what's roughly proportionate, I think there's a misunderstanding here, a fundamental misunderstanding of what we're talking about when we're talking about proportionality. And in Dolan, it says that it is not a mathematical equation. We're not just measuring dollar for dollar whether or not the cost to develop the road up to standard is, fits within the profitability of a project. It's a comparison that just prevents the government from imposing conditions that are unrelated to the impact of the development or go beyond what is reasonably necessary to address those impacts. Imposing a condition to straighten out the road and bring it to a major local standard is directly tied to that subdivision and bringing additional people to the area. It is reasonably necessary to address the impacts of increased traffic. The standard is, it's not whether or not it's expensive. It's not whether or not it's going to be costly or difficult. It's just whether or not the exaction is tied to the county's legitimate police power and interest. And so in this particular case, because we're at the foot of a hill, it's going to be more expensive than developing the road up to standard on a flat piece of ground. And that's an accident of geography. That's not the county's, the county didn't make it expensive. It's just the condition of the property that made it expensive. And what we're looking at in proportionality is just whether or not the county's exaction is tied to the legitimate police power of health and safety on the road. And so we're not asking them to put in streetlights. We're not asking them to bring it up to an additional road standard that is greater, like an arterial road. I just wanted to, focus on that this proportional standard, it's not a mathematical equation. That's a direct quote from Dolan, that it's not, we're not looking at dollar for dollar. Is this going to make the project unprofitable? What we're looking at is it rationally tied to the government's legitimate interest, and is it reasonably necessary to address those impacts?
So I was going to talk about the standard. My understanding is this road is classified actually on the county's transportation plan as a minor local collector, which is a step up. Is that correct?
I would have to defer to our public works on the exact classification of that road.
I think that's what I saw in the staff reports, that it's, the local collector is actually up. So you'd have to defer, so you may not be able to answer this, but it seems like the county actually imposed the next standard down, which is major local standard instead of that. That's right. So I guess I'm getting from the appellant that is right, the county imposed a lower standard, but okay, I was just wondering if you had anything on that. And then
Which, if I could comment on that, I think that helps the county's case. We're not asking them to build it to an arterial road or a major collector. If it's currently classified as a minor collector, which I'm not sure if it does, but if it does, and we're asking them to approve it to the standard of a major local, that's the standard below what it's classified as. So I think even if we're looking at it under the same standard, the county could have conceivably and reasonably asked them to bring it up to the standard of what it's currently classified as, which would be more expensive. So from the perspective of the county is only asking them to develop the road directly on their frontage. We're not asking them to, because there's a problem in development of the pioneer who is the first person who builds out there. We don't want them to have to bear the cost of developing the entire road that gets all the way out to their development. But at the same time, we can't, because then that would allow all these free riders to impose on the first person. But at the same time, we can't allow them to skate by without paying for their impact. And so, what the county asked of the appellant is that they develop the road up to the minimum standard that we impose for their frontage, and to a standard which it seems to me, based on what you've just told me, is below the standard of what the road is currently classified as. And again, this point is, it's not a mathematical equation. It's not dollar for dollar. We're not comparing whether or not it makes the development profitable or not. We're looking at whether or not it is reasonable to mitigate the impacts, and whether or not it's related to the county's legitimate police power.
okay, I think I've taken your arguments. I think I appreciate that. I did have one more question about the, I take your argument about the mathematical formula, but about that mathematical formula, in my experience, a lot of local governments will simply require a developer to just build whatever roads are necessary. This is a payment, it seems like a fee in lieu, so
The fee in lieu is just a tool that allows developers to be able to pay their fair share to address their impact, but also allows the county to build the roads in an organized manner. That way we don't have developments that bring one section of road up to standard and then have either section on either side not be up to the standard. And so in this case, that was offered as an option to the developer to pay a fee in lieu of. And under county code, if that fee in lieu that they pay is not used within a certain amount of time, it will be paid back. But the county generally use it, as people develop on these types of roads, they store that money up and then they will do it all in one big go. So the fee in lieu is not tied to whether or not it's proportional. It's a tool that is a tool of convenience for a developer.
if I'm understanding correct, they could choose to build the road.
They could
just at their
choose,
own cost.
correct, they could choose to build their own code.
Or they pay the county a number that somehow, I believe, the appellant and the county somehow work together. They come up with, here's what we estimate the cost of this road to be.
Right.
We pay that amount, and we're gonna use it when we ideally have a longer road project where we can do, a longer stretch of it. We get some cost savings there with other development.
Correct.
Or if we don't do it in a certain amount of time, we'll refund it.
And the cost, the cost to build the road to this particular design that was submitted, there are other designs that can meet the county standard. This is not the only design that can meet the county standard. And this design was generated by the appellant's own engineer. So they could go back and say, look, this design is going to be really expensive. Can you figure out another way to engineer the road to meet the standard? That could presumably come at a lower cost. And if the developer so happens that they have access to cheap materials or some other way that they could do it cheaper in a less expensive way that still meets the standard, then that would work as well.
Okay, I think those are all of my immediate questions. Anything else you want to bring to my attention?
I would just circle back to the main point that this discussion of the Nolan-Dolan standard, whether or not it's roughly proportional, that should take place after deciding whether or not the appellant's appeal is timely under our code. And if it is timely, then we can have that discussion. But if it's not timely, then it's a moot point and it should be denied.
Okay, I appreciate your arguments on that. If there's something else in the county, I'll invite the appellants to respond and make any
Thank you.
discussion. You can come to the microphone if you'd like. That'd probably be better, just to make sure we get you recorded.
So, just wanted to, we'll hit kind of those same points kind of in order. Hopefully I can remember everything that was spoken of. So, first off, we're not appealing anything that was talked about in that meeting on that date. So, the day we're going by is actually August of 2023. So, because what happened is when we came here to this same room, we had that meeting, we agreed, like, it was a good meeting, we got this initial subdivision approval.
Back in August of
Yeah,
22.
2022.
Okay.
But what wasn't settled in that meeting was the fee amount. So we didn't know the full stance of the county's take on the fee until we met in August. And that's when they said, no, this is the full fee. And that's when we decided, hey, we've got to really look into this and appeal that. So and in fact, in that very meeting in August, I think it was the first week of August. I don't know the exact day, but we could get it.
This year.
Yeah, of this
Okay.
year. It was actually their attorney himself that told us we could appeal it. So we decided to look into it, and we got that appeal in shortly after that meeting. And on that topic, we emailed the county and said, hey, we want to appeal this. And their first take was, hey, you're past the date. And we said, well, actually, we're not appealing anything that was decided at that date. We're appealing the fee amount, which was discussed August 2023. And we waited for their response and they responded and said, okay, we can do it. So we submitted the application and paid the $350. So the county is the one that agreed that we could do this appeal, and they even told us in person in that meeting in August 2023. So we're not appealing anything that was made, any decision made in August of 2022. That, we agree with all that. And so I think with that being said, that should handle his first and main point, which is this wasn't timely. And if you really want to talk about timely, we could go into a whole lot of other things that we had to deal with the county. And we don't need to get into that, that's not part of this hearing. But
Could I also want to get some clarification. So this year's meeting, August 2023.
right.
So this is, you're saying, okay, we're not challenging the previous decision. It's this August meeting, and we timely challenged that. We did file our appeal pursuant to what the county told us. We also
Right.
got within the 10 business days of that meeting.
Yeah.
So that meeting, I don't have much in the way of records from it.
So we could look it up. It's in our emails.
Um,
But so
The fee amount was established at that meeting?
no, so we didn't even know about this appeal until that meeting. So at the end of that meeting, we asked him, so what else can we do? And Taylor, Mr. Sorensen, is that right? Sorry. Okay, Taylor. So Taylor in that meeting told us that it was an option. And so that was the first meeting that we had where we found out, okay, this is what the county is saying is our fee. Because we had the estimate before that, right? Because we got their estimate with our engineering group, who's also the engineer that works with the county. And so we're like, okay, here's what it would.
When was that estimate?
So that estimate was a few months before that.
Okay.
But we didn't know that we were on the hook for that, because when we talk about these fees, like my family's developers, and most of the time, when they're doing a development, they are only responsible for half of that road, because someone else owns the other half of the road. So this whole time, I was under the impression, all right, well, here's the cost of the full road. We got to meet with the county and figure out what we're responsible for. And then when we finally sat down with the county, they told us, well, no, we think you're responsible for the whole thing. So that's when we finally realized, okay, well, that's not acceptable. Our impact on the county for this subdivision is not $170,000. And I know he mentioned that it doesn't go to cost, but I have the state saying otherwise, which I can quote. But anyway, so we can get you the dates. I don't have them off the top of my head.
They're public record as well. So
Yeah.
I can look those up. I'm not too worried about that. I'm just
Yeah.
trying to clarify
Anyway,
when
that's
things happen.
Yep. So anyway, I don't even know how quick. I think it was 13 actual days that we got that in, because we didn't even know there was a 10-day limit. We just told we could do it. So we did the paperwork, and we were waiting for the county to let us know we actually could. So anyway, that's that. So it was very timely. On our part, as soon as we found out about something, we've acted very timely. And I know the county's busy. Everyone we've worked with at the county has been great. Timing has not been great, but they're good people, they're busy, and we understand that. So anyway, so that first point I don't think is relevant. We've been acting as timely as we can with all the information we had, and surprisingly, I think we actually did get it in the 10 business day window without even knowing that was a requirement. So anyway, to the next topic, unless you have any other questions on that.
Timing. I think of any, I'll let you know, but nothing on the
Okay.
timing right now.
Okay. So as far as everything we've read from these two other cases that are setting the precedents and the state's outlook on them is, it doesn't matter what the county code says. They can only extract from you an exaction that is equal or less to your impact. And they even say, and this is from the Utah Office of Property Rights Ombudsman Advisory Opinion 249, according to the Utah Supreme Court, for the extent proportion of the analysis, specifically, this implies that both the execution and the impact should be measured in the same manner or using the same standard, the most appropriate measure being cost. Therefore, the extent analysis is distilled into comparing the respective cost to the parties. And so our subdivision, it's not just roadway impact, right? It's everything. We're bringing up the power. We're paying to bring the power up. We drilled wells. We're doing septic tanks. Okay, there is no utility from the county. Everything is on our side. We're paying for everything other than, I mean, obviously the road situation, right? So other than the road, then you could get into, well, school buses and garbage and snow plows. All of those things already go past our property to do a turnaround about a quarter mile north of us. Every one of them. So there's no impact there. I mean, obviously there's going to be more garbage cans, but we pay for that service, right? So all of those little things are covered in ongoing costs to us once it's developed. Taxes, the sewer or garbage fee that we're going to pay when they come pick up our garbages. So really, I mean, other than very, very minor things that maybe you could think of, you know, maybe if we had to call the police department to come settle something, but in reality, the police are going to have to come to this intersection less now that it's a subdivision. Because right there is where everyone likes to come and park and do drugs and all sorts of stuff. And even since I've been there, like working and getting stuff set up, people pull up and they drive off. And once this is a subdivision, there's homes there, they're not going to sit around there. So cops are actually going to have to be called to this less than once with the subdivision. So anyway, that being said, the main cost that we're looking at is the road. Other than that, everything is pretty, like, unsubstantial. So what we've done is we've put together, and I agree with him, it is more expensive road. It is in a terrain that has turns and, you know, slopes and hills and everything. What we're coming up with is based off the estimate for this very road. So we're not saying, hey, this should be an average based on other subdivisions. Like the price we're coming up with is based off of this very scenario, our own, the very estimate that we've been talking about. So if you look at it, we talked about it, right? So he talked about, you know, what was it? He talked about being the first one to develop, right? And then everyone gets a free ride, right? Freeloaders. The road, and he talked about where our road comes off. Our road comes off the county road that is already paved and up to standard.
Where is the county road?
So the county road is the one that curves a lot right there.
Right.
And then the new road is the one that curves a little less. And then our private road is actually might want to go back to the other one. So our private road is that little hexed.
Xed
Yeah.
off thing going.
Right, so it comes in to a paved county road. And all of our traffic, except for maybe one out of like 30 times, we might go south instead of north. If you look at the traffic, the county has even told us that 250 to 300 vehicles travel on that road. And according to the county standard, every home that's built is equivalent to 10 cars traveling on the road. So that's a total of 15 cars per day that we might bring in. Yeah, I don't think it's going to be that much, but let's say it is. 15 out of, we'll say 275, that's in the middle of their estimate. 30. Well, yeah, sorry, 30. 30 out of the 275 gets you just over 10%. And if we want to even take the full width of the road, and not just half, which I think really we should only be responsible for our frontage, not the whole road. If we take the full width of the road and take the full estimate and say, okay, 10% of that, because everyone else is using that road. We aren't requiring this road to be at this big, nice, get the turns out of it because we're adding 15 cars. It already has 300 cars a day. So what we did is we said, okay, 10%, we did all that math, it comes out to be like about $62,000. And then we would give the almost half acre to the county as well, which that total value is just over $80,000.
That first estimate's about how much?
What is it? No, what I'm saying is,
Just for the record, if you're talking from the audience, you might.
oh yeah, you can come up here. Okay. You can sit here when you're not. So anyway, so let me, actually, we have it all right here. Okay, so using the engineer estimate, which is $163,961, to bring the frontage road and everything, the full width, That's the total. And our usage, according to the county, is 15, or it would be 30 cars per day, 10 for each lot, comes out to 10.9%. That 10.9% of that total is 17,872. And so way below. Like if you're just going off of what cars we're using, like our impact. Now we understand that, you know, I know that there's other impacts and they're small, but we can't put a number to them. And that's why we're saying that we're willing to pay more than that 17,872. The total value we're trying to give the county is $82,000, which includes the land that we're giving them. And the reason why this is, I think, totally according to the law is that, and that's why I love the fee in lieu of mechanism, because the fee in lieu of mechanism allows the county to get what they need, and it allows the developer to really contribute what their impact is. Because we don't have to build the road. They've already established that the road doesn't have to be built for us to get this subdivision. But we do have to pay a fee.
I want to clarify something. So the reason why the county went with a fee in lieu, and they said that's a good idea, is because if we did our frontage portion, you could see it goes into a field.
Right. If we built the road, it would end in the neighbor's
And
field.
so the county would have to finish the road, and they haven't been ready. They've been needing to do this road for many,
Right.
many years and have not been able to, and so, or haven't chosen to do it. And so they said they're, on their timeline, they don't know when it'll get done, sometime down the road. So that's why they said the fee in lieu is great, because then we'll hold the funds, we'll hold the land that you dedicate, and then we'll do it on our timeline.
Right. And I think everything that's happened so far has been exactly what needs to happen. The county's made the right decision, the fee in lieu, because we're trying to live here. This isn't like some economic, let's get rich, develop a subdivision. We're just trying to create a scenario where we can live out in the county with our kids and be part of the county. And we like everyone we work with so far. We want to pay what's fair and contribute to the county, but we don't want to pay for a road that everybody's using and they're taking advantage of us to get it built.
Let me ask couple clarifying questions about what you've just said.
Yeah.
So, main traffic coming out of this. So this is this 2400 West. That's
Yeah.
the road.
Yep.
This is the only real access this subdivision has to the public road network, right? Like this is your access to get everywhere else in the county.
Right.
You have the private road for the lots, but they all feed into this, and this is
Right.
how you get it. Okay.
Yep. Yep.
The proposed new road, where it kind of does the less sharp curve,
Right.
it just would dead end into the
Neighbor's
stub into
field.
the neighbor's
Right.
property.
Unless they were ready to
Unless
keep
they're
building.
ready to build and
Yeah.
connect it
Yeah.
through. Right now, it's just stubbing. The current road, primarily traffic flows north, is what you're saying?
No, it goes both ways, but everything north of there is paved. Like it's a good structure. I think it's to the standard of the county-ish. Yeah, so it's,
On the corner of your property.
yeah, so where our private road comes in, it's pretty much to the current standard. I mean, it's an older road, but it's to, I believe, the current standard. And then about, like 20 feet or so south of where our road comes in, it becomes a dirt road.
And that dirt road is what leads to two
Paradise, it goes into
Paradise
Paradise.
and Avon, which are just mountain communities, which
Right.
we may use from time to time. but
So people do travel
majority-
back and forth, but when we leave our house, unless we're going to Paradise for some reason, we won't even go that way. Like everything, food,
freeways,
groceries,
everything is
gas
the other way.
stations, everything is to the north.
Which would be until the road connects through along the existing sharper,
Right, and it'll stay that way.
until.
And I think the county has 12 years. After 12 years, the money would come back. So it may stay that way for 12 years. I don't know. It just depends on the county. Yeah.
That's helpful. I wanted that clarification.
So anyway, so the point being is, so going back to a couple of the points that the county had that they talked about is the collector road, the estimate they were holding us to is the local.
Major local.
It is status as a minor collector. And that's their way of saying, well, we're not we're not making you pay for the whole community road, it's just the minor one. The difference in those was like $15,000, right? That's not the way to measure and set up, we're not making you pay for the whole road, right? That is not equitable. The equitable way to do it is to say, look, the community uses that road this much, you guys are gonna use the road this much, right? just to say, you know, we're not making you go to the full community standard isn't an equitable way to split that. So,
It actually, in the Utah Department of Property Rights Advisory Opinion 249, which the ombudsman put together for another opinion, they said there certainly must be some effort on the government's part to quantify findings to parse out the impact of the proposed development from the rest of the impact of the greater community, when the issue is determining who will ultimately pay for roads that also service the community at large.
Right.
So the issue really is, like, this is like a commuter road, a collector road, and regardless of the difference in the amount of cost to,
Right.
yeah, to improve those, the point is that it's used by many other people.
right, so essentially, when it all comes down to it, that $82,000 that we think is more than fair, because when you look at the actual impact, I believe it's less, is half the cost of the full road. And that's what I'm used to seeing developers do, is their frontage of a road. I think we're going above and beyond what our true impact is, and I think it's also in line with what I've seen other developments do. And now, when you may find other developments and say, oh, they did all this other extra stuff. Well, they might have been given 60 units, right? We're looking for 3 county homes.
Yeah, I think the interesting thing about this is there's a lot of weight put on the county code. This is what's required if you're going to put in a subdivision, or even if you're just going to build one house, you have to improve this road. They have no mechanism for proportionality, because if we were to build one house, or if we were to make a subdivision of 20, it would be the exact same requirement. So they have not put in place
Right.
a provision.
Which tells you that their provisions aren't set up to be set to your impact.
Yeah, there's no proportionality put in there, which I think would be a good idea
Right.
for the county to look into that, because it has really influenced a lot of people who just want to build one home,
Right.
but they can't
'Cause-
at all.
So their stance, when we asked them, was whether you build just your home or do a subdivision, this is what you have to do.
Or if the subdivision's 3 lots or 20 lots, you still have to do the exact same amount.
So
that's
anyway,
why we're trying to look at
But,
what's more
and that's
proportional.
why I think this fee in lieu of is the perfect mechanism, because it allows us to satisfy their requirement, but it also allows us to pay our share, not the full road.
So if I'm understanding correctly, what you would think, based on the proportionality analysis, that you would say roughly fair, or maybe not even fair, but livable for
Yeah.
you is, we'll dedicate the width and we
Right.
pay for half, which is roughly 82,000, because the
Right.
total amount was just under 164. So we'll say 82 is half, we're covering half of the road. We will assume another developer will cover the other half on the other side, and the road is now dedicated as that. Something,
Yeah.
is that?
So the 82,000 includes the value. So the actual payment we're
The
gonna
value
give
of the
them.
land.
It would be a little less, because
The
the
payment
value,
would be like
so the value of the
65.
land, according to the county's estimates on acreage, it's 0.43 acres that we're dedicating, which is a $17,200 value. So we're putting that 17,200 into the 82,200.
So
So you
the
wouldn't
fee
make
we-
you'd make
So
a
the-
65?
Yeah, exactly.
So you're suggesting, so 65,000.
So we'd make a payment of 65,000 plus dedicate the land.
So your plat does show the right-of-way dedication, so you're saying we're gonna include that as part of our overall
Right,
proportional
because
analysis.
the whole thing we read in here too, with the state's take on these cases, is that that's part of building up that cost. When you look at the cost, we're giving a value to the county by doing that. And so when you come to that common standard that they tell you should do, which almost every time is dollars, you take into account the land given as well. And so that's why we're using that value into the 82,200.
Yeah, they say
That
it's
is helpful for me to understand how
Yeah.
the numbers
Yeah.
Yeah.
to it.
So 65,000 as a fee, and then dedicating our land, which the total value,
Shown on the plat.
right.
Yeah.
And then I think there were a couple other points. We talked about the geographic, cost is higher here, and we've already settled that, right? We're using the actual estimate for this location. We've talked about the freeloaders. Like, we're not trying to freeload. Like, our road, it is good all the way up to our road. We're not trying to freeload. In fact, what we're doing is we're building the road for the next person. We're paying money for our road to extend to the next lot. We're not freeloading. The next guy is going to be better off because of it, because of the money we're putting in. So we've covered that. We've covered the geographic, extra cost. We've talked about the collector road and servicing the community.
Yeah, and ultimately, by us coming in and doing this and dedicating a portion of our land, which the county, if we didn't do any development at all, when the county decides to do this road, which they've been planning on and needing to do for a long time, it's clearly in an unsafe condition at that turnaround. And the county was already planning on doing that. So by us coming in, we are giving them this land that they'd have to come to us if we didn't
Right.
develop and say, hey, we need to buy this from you anyway. And
So-
then they'd have to front the whole
Yeah,
cost of
so
the road.
essentially, we're giving them the 65,000, which they would have had to pay on their own.
And the land.
And they don't have to fight us to dedicate land. They're already gonna have the
So it's a
land.
win-win. We just wanted to make it more proportional because we didn't feel like it was proportional to our impact.
I just want to make sure too, did you get our response?
Yes, I'm looking at it right here. And
Okay, yeah, I just wanted to.
As you were saying, I was like, you did read,
Yeah.
explain how you calculated it, and I had
Yeah.
read it through, I just forgot in the moment
Okay.
that that
Yeah,
was how we were
that's
going.
okay.
Okay, yeah, I just wanted to make sure you had it so that when you can.
I absolutely have it. Let me just make sure, but I have an application, it has your, application form, it's a 2-page form, and then I have a statement, August 15th, 2023, 3, 4, 5 pages, and then a couple of exhibit pages, or 3 exhibit
Yeah.
pages.
Okay,
Okay,
yeah.
I have reviewed it and I have read it. I
Yeah, and
appreciate
so
that.
I guess maybe just going back to the main point, why they wanted to dismiss this was the timely manner is, we've been
Yes.
very timely. We're not disputing anything that happened last year. We're
Yeah.
disputing the,
So let me ask you a couple questions on it.
Yeah.
I'm gonna get a little, not little, I'm gonna get very specific here.
Yeah, yeah.
So we have, in August, I have a staff report, August 4th, 2022, prepared by the county. And it talks about the road, and the road manual has like findings of fact 13, findings of fact 14, talks about the road and 2400 west. And it lists 2 conditions. Condition 5 says, prior to recording the plat, the applicant must bring 2400 west into compliance with the requirements for a major local road, and continues, basically you build it to county standards.
Right.
Condition 6 says, as an alternative to completing the required road requirements, prior to recording the plat, applicants may enter into an agreement with the county to pay in lieu fees for the cost of the required road improvements. And then there's some language there.
right,
So that's part of the staff report. The following day, of August 5th, 2022, I have a letter from, looks like the county planner Angie Zetterquist. Says, August 4th, County Planning Commission approved your request for Monticello Meadows subdivision based on the findings of fact, conclusions, and conditions identified in the staff report. So this is something that I'm gonna be looking at closely. We have a condition that says, improve 2400 west or pay a lieu and fee for 2400 west.
right.
And it seems from how I'm reading it, it is all of 2400. It just says, do the road and bring it to the major local standard.
Right,
And the staff, and the notice of approval says the commission approved that with that condition as part of it.
right,
So why should I not say, well, it seems like you agreed at the time that was the standard?
right, because when we see that second, or the number 6, where it says fee in lieu of, and we already know that they can't just ask anything, right? So when we see the fee in lieu of, we're like, all right, we'll take that route, because then we're gonna find out how much we owe them and what is our impact. So even though it was written that way, in our mind, it still doesn't mean we're paying the full amount. And so in our mind, we're saying, okay, it's approved, but we're gonna come up with how much that amount really is once we look at what's fair and equitable according to the state.
So let me ask this question then. The 163.9, whatever it is, just under 164,000.
Right.
Are you disputing that that's a reasonable estimate for doing the whole width of the
Yes.
road?
No. That's a
I know you're
reason,
disputing that
yeah.
it's reasonable for the impact on your development. I'm saying, is that a reasonable cost for doing that width and length of the road?
Yeah, we're not disputing that.
Okay. So you're saying, we didn't know that number, we knew we had to do a fee in lieu, we didn't know what the number was going to be.
Right.
And maybe we didn't even understand that that really meant the whole road.
Right, so at that point, we didn't even have the number, first of all, right? We knew that was written, we didn't have the number, and then once we got the number, in our head, it's like, okay, now we know the whole cost, because even the county, when we were working with Matt, said, that'll give us the whole cost, and then we can talk about what the fee is. Like, our whole conversation the whole time wasn't, yeah, you're gonna pay the whole thing. Let's get the cost and then we'll figure it out.
We've been in negotiations for a while.
Right.
Makes sense.
So from the very beginning, there was nothing set on this fee. It was, we gotta take care of what is required and what was in the meeting but the fee has always been up in the air depending on what is negotiated, what's fair, what's right, according to the law, according to what the county needs.
Okay.
And here's the thing, if we really go by the law and you read through every one of these, like, it really is truly, what was that number? Like 17,872 is more fair. And then you apply the value of the land and it's really like next to zero as far as dollars go. But we understand the position the county's in and making sure roads are taken care of with developers, and we want to do our part. That's why we're bumping it all the way up to pretty much half the cost of the road once you put in the value of the land.
Let's see, do I have any other questions? Yes.
Because trust me, I mean, we are gonna be members of the county. And our taxpayers, our tax dollars are going to the county to build other roads. And I hope that in future subdivisions, the county figures out what is truly the community's impact and what's their impact. I am totally satisfied with my tax dollars going to pay for someone else's road that is used by the community.
Appreciate that, and I believe the county will appreciate that as well.
Yeah.
Let's see, last question I had written down here, the road standard, we talked about I'm talking just the current condition of the road.
Yeah.
I think the county said it's substandard and it's not well maintained or something. Do you agree with
The
how?
dirt part.
It's maintained, it's just,
The southern portion there?
yeah, so one thing the county could do in the meantime is lower the speed limit. I mean, yes, the speed limit is too much for that road, but just lower the speed limit. Like, cars go off of that road every year. In fact, I get 2 or 3 calls a year from the county sheriff saying someone off the road, here's their insurance information.
But I think it's important to note that we are not being held responsible for this road for the safety reason. And the county's made that clear because they've enabled us to do a fee in lieu. Because if we were to build our portion, it'd go into a field.
Yeah.
And so the county said, okay, we'll do this when we're ready. We haven't been ready for the past many years. We'll do this when we're ready. So it's not that big of an issue to them, apparently.
And
Otherwise, they would have done it already.
I get development, I get where the county is, they have limited funds, but at some point, they do have to own up to what's truly the county's cost. And the reason I get the feeling that they don't fully do that is in our last meeting at the end, they mentioned that, well, if you don't develop, we can wait for the next one. And that tells me that they are just wanting to take advantage of developers. Like, at some point, you have to budget for what you're responsible for and not just hope a developer comes and you hit them with the full cost and hopefully they're making enough money to pay it and not fight it, right? And, you know, if this was a huge development and I could pay it and I didn't have to go through all this, I would have done it last year.
If we had 15 homes that we were putting in, it would
And
seem so much more reasonable.
obviously, we're not using that as our argument, because like he said, you can't go off of the profitability of a project for the argument. We're not doing that. We're going off of what is
Impact.
our impact, what does the state say about it?
Yeah, if we were putting in 15 lots, we would say, oh, this is more of a reasonable, like, exaction for us, because we are definitely putting more cars on this road.
But anyway, so I think we've gone through everything. Did you have any other questions on any of
I
them?
was looking over right now to see if I scribbled down any other questions to ask.
And I can't remember if there were any other points the county had in their submission that we didn't talk about, but
Oh, the
Who wanted to
county,
address?
I did have one more question. So the council for the county said something, I wanted to get your take and whether you agree or not. The design of the road, the engineer was your engineer, the county's engineer? Is it?
it's kind of
a little
both.
bit confusing?
So Matt can speak more to it if I don't capture all this right. So Steve Earle does work for the county, and we also had him do our plot map. And so we just said, well, if he does work for you guys, let's have him do the road, because he's already doing our plot map.
So a contract engineer who also does some
Yeah,
contract work for the county.
so it was just
Yeah.
synergy, it was just synergy so that the county could use someone they're already used to using, and, yeah.
So the county says, come up, we're gonna need 2400 West improved, give us a design. You say, okay, we'll get an engineer who knows county standards to do it.
Right.
Yeah, in fact,
And it was commissioned by the county. They just used our same engineer because he was doing the plot map.
yeah, it was
Oh,
done
okay.
all through the county. We just followed up to make sure they were doing it. 'cause
But
it
the
was taking a long
contract
time.
for the road design was through the county.
Okay, that's good for me to know. And then for the plat, you said it's the same engineer, but, so this road alignment, who required that? I know the county says they required it, but you've proposed this plat. Was it part of the discussions beforehand, before you submitted?
No, so when we first, okay, so we'll give you some of the history. I was looking to buy this land. It was about a year and a half into the process, and I got it under contract. I had a due diligence time frame. I called the county. I said, hey, what's required for this road? And they told me it needed to be a dirt road, about 20 feet wide, and proper slope. Nothing about this new road. I closed on the contract a month later. A few weeks after that, I called the county and said, hey, I want to get moving on this subdivision. We want to move up there. And they said, oh, we just re-statused that road.
Not restatus, something else.
Or, well, the road is status, but there was another change, and I don't know if it was for this. It probably wasn't. Probably wasn't for this, but the point being is, we were kind of blindsided by, now it's this versus all we really had to do before is grade it, make sure slopes were good.
Which I can, codes and standards change.
Right, and that's, it is what it is. That's why we didn't
Yeah,
bring
we've
that up for the
accepted
argument.
that.
My question
yeah.
was more just, this specific plat map that shows the road going off to the side, how did that come about? Did the county say, you're gonna need to realign it because of speed things, so show
Yeah,
it on
so
the plat, or?
it was the same engineer we used, but he worked with the county to make sure that they got what they wanted.
Okay,
Yeah.
that's what I wanted to know.
Yeah.
Perfect.
So all the coordination for that design was with the county, but it was the same engineer we used for our plat map.
Okay, let's see, are there any other? Okay, I don't have any other questions. Is there anything else you want to?
So, yeah, so I guess just for our information, like, so where do we go from here as far as you review all this?
Yes, so I was actually going to explain
Okay,
that.
yeah,
So, I think we're done with the argument side of this. I've received some good arguments, some good thoughts. I appreciate the time and effort you've all spent on this. Obviously, it's very important, and I want to make sure I take the time to review it because it is important. Where we go from here, I will issue a written decision. I believe under county code I have 15 days to do that. I'm going to try to do it sooner. I don't like to leave people hanging. You're obviously on anticipation for this decision.
That'll be the most timely reaction to what we're doing in this whole process.
I'll just say, it is Thanksgiving next week, so I may not do it on Thanksgiving Day, but I will try to get it as soon as possible, just for everyone's sake. And then, once I issue that decision, both sides, depending on who I agree with or what position I take, there will be a further appeal right. Either side can appeal my decision up to the district court. I would have to double check the timing. It is, I believe, 30 days by state law. I don't know if the county has more time than that. I know state law is 30 days. I don't know if the county allows more, but I would say, at the very least, it'll be 30 days. When I issue my written decision, I will include, the final paragraph will be, anyone who disputes this decision, here's how you appeal my decision.
Okay.
That'll be a written decision. It'll go through these arguments. I will, in the meantime, re-review everything that you've submitted, everything the county has submitted, and my notes here, and then I will issue a written decision.
Okay, and then if you have questions with anything, you're free to reach out, I guess, to both parties. I don't know how that works, if that's
I
allowed.
probably, at this point, I'm treating it more formally, so I won't be reaching out to anyone. I'll just make a decision.
And then, so just to make sure I'm got it understood, so once the decision's made, we have 30 days to decide one way or the other?
Yep, so if I rule in your favor, the county can say, well, we don't agree with that. We're gonna take it to district court and appeal it, and they'll have to do the whole court
Okay.
process and notify you. If I rule in favor of the county, then you'll have that same right to take it up to court and do the same
And if
thing.
neither party does, whatever you say goes?
If no one disagrees with my opinion and appeals it, my decision is final.
Okay. Okay.
So unless you do some new application, but that is far beyond what I can, I can't decide whether to change an ordinance or to impose recommendations on how the county should do things. All I can say is, in this very specific circumstance, here's what I think the law is, here's what I think the evidence supports, here's the decision, and if you disagree, how to take it to court. I can't
Yeah.
do much beyond that.
No, that's understandable. Thank you.
Thank you. And thank you, council, for your time and for everyone's time. At this point, I will,
Do you care if I ask Taylor a question? I might have, there's been some talk of some just general information that I think might need to be clarified, especially on the half road width. So I just didn't know, do you care if I talk about like the half road width a little bit?
Yeah.
Of why maybe in this case, the half road.
well, let me explain it this way. The evidence I'm reviewing this on the record. So I'm reviewing the information that's already been the basis of the original decision, and they've submitted for why they believe it should be different, but I'm still looking on the record. So I don't really want to take too much evidence, but if there's something factual I'm missing, I'm happy to get a correction, and then I would allow you to respond as well. I'll let you decide whether you think there's something I need to have corrected, and we can even take a short little recess if we would like.
Yeah, if there's something that's not reflected in the,
It's more of a scene of being brought up, so I don't want to bring it up as evidence, but in the county.
Matt, you should probably introduce yourselves and.
I'll come back.
So why don't you come up, say what you say, I'll let the appellants and then have a time to respond as well if you would like.
Yeah, Matt Phillips, I'm Public Works Director. I know you asked a question about a half road width. I know it's been brought up by the Schlauenbergs as well. In the county, that our road width is the minimum road width that's required for health and safety. So in other cities and communities, they might have a 30 to 40 foot road width. So I think that's been brought up where we talk about a half road width. If we, at 20 feet, 22 feet wide, a half road does not meet minimum health and safety standards from a fire and an ambulance and those types of things. So in the county, we don't really discuss half road widths just because our roads are already at that minimum width and standard for health and safety reasons. So.
I also mentioned we don't require curb and gutter and sidewalk.
Yeah,
Those other
curb, gutter, and sidewalks. So, in the county, that's not really, usually half roads aren't discussed because we're not at 30, we're not at 40. We don't have, even in cities, when they do a half road, it's still at a minimum health, safety standard for ambulances and fire and that. The other part is, when we've talked about the fee in lieu of, the reason it was an option in this case is because there's no way for the applicant to complete those road standards without affecting the neighboring properties. So the fee in lieu of has certain conditions that it's only allowed under certain conditions by the county code. And because this road, the road design meets one of those criteria, that's why it's an option. If this road could be completed and brought up to standards within their property, that fee in lieu of would not be an option. So fee in lieus are not an option for every subdivision, only when it meets one of the 3 criteria listed in the code. So.
Appreciate that clarification. Anything you'd like to please come up and just introduce yourself again, just so the record's clear. Sorry.
I introduced myself the first time. Jacob Schellenberg, I'm the one that submitted the appellant. But so I agree with that, right? Like it does have to be fully built if that's the safety of the road, right? You can't just build half a road and then people are wrecking and on 2 different surfaces. But it really is a moot point just because it's a fee in lieu. Like the road isn't being built, right? And that's why I think the fee in lieu is such a good mechanism, because it allows both parties to come to a fair, equitable agreement. So anyway, yeah.
I appreciate that. Any other final, I guess, last call for? Okay, then with that, I again appreciate everyone's time and attendance here and everything you've submitted. I will review this all and try to make my decision as soon as possible. Thank you again for your time. Call this hearing adjourned.